Yeah. It is very small. It is looking na
Yes, ma'am. Yes, ma'am. It is visible.
visible.
Yes, ma'am. Yes, ma'am.
Can I proceed with this, or can I proceed with laptop? Yeah.
Laptop no
It is
problem,
very
but
small. It is looking na
other numbers are not visible.
not visible.
Yes, ma'am.
Going,
Yes, ma'am.
sir. Can I proceed with this, or can I proceed with laptop? Yeah.
Laptop no
It is
problem,
very
but
small. It is looking na
other numbers are not visible.
not visible.
Yes, ma'am.
Going, sir. Can I proceed with this?
Of being incompetent, mental health is confidence, dreams and some honestness. I'm not here to save the day, that's for you to take away.
Another slide, ma'am.
I'm connecting in my laptop, sir.
Yes, ma'am.
Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Yes.
Can we go to another slide, ma'am?
Yes, sir. I'm connecting in my laptop, sir.
Yes, ma'am.
Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Yes.
Can we go to another slide, ma'am?
Yes, sir. I'm connecting in my laptop, sir. Another slide, it is not. Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Sir, again I am.
Can we go to another slide, ma'am?
Yes, sir. I'm connecting in my laptop, sir. Another slide, it is not. Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Sir, again I am.
Can we go to another slide, ma'am?
Yes, sir. I'm connecting in my laptop, sir. Another slide, it is not. Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Sir, again I am.
Can we go to another slide, ma'am?
Yes, sir. I'm connecting in my laptop, sir. Another slide, it is not. Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Sir, again I am.
Can we go to another slide, ma'am?
Yes, sir. I'm connecting in my laptop, sir. Another slide, it is not. Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Sir, again I am.
Can we go to another slide, ma'am?
Could you please share, sir? Yes, sir.
Can you do
I'm connecting in my laptop, sir. Another slide, it is not. Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Sir, again I am.
Can we go to another slide, ma'am?
Could you please share, sir? Yes, sir.
Can you do
I'm connecting in my laptop, sir. Another slide, it is not. Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Sir, again I am.
Can we go to another slide, ma'am?
Could you please share, sir? Yes, sir.
Can you do
I'm connecting in my laptop, sir. Another slide, it is not. Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Sir, again I am.
Can we go to another slide, ma'am?
Could you share, sir?
Second,
Yes, sir.
can you do
I'm connecting in my laptop, sir. Another slide, it is not. Is it okay, sir?
It is okay, ma'am. Another slide, ma'am.
Sir, again I am. Could you share, sir?
Can you go to scroller row, ma'am?
Scroll.
Scroll row.
Scroll. By scrolling also it is not coming, sir.
Okay.
Could you please share, sir? Because
Your keyboard, ma'am, you will do settings. Scroll down, ma'am.
scroll down, it is also not coming. Enter also not coming. Then page down.
Okay, okay, ma'am. I will check it, ma'am. I will check it.
Yes, sir.
Ma'am.
Something not illogical, something that is topical. Rub it on and watch it go. Make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable. Thoughts in my head, a collage and they spread. I'll be great one day, going off of my meds. No, I'm not giving up, no, I'm not giving in. I will make it to the top, taking off in the wind. I gotta make it, I'm saving every day to taste it. I'm patient, but my mind, it can hardly take it. I'm chasing a dream that I've had for several ages of vacant. Modern kingdom, Now that I've been put through hell, I never got anyone's help. I had to do it all myself. I don't ever slow up, no I don't take shit. I got no love for the fakeness.
Sir, is it okay?
And wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love
Yes, sir.
for the fakeness. If you wanna play tough and
Scroll open na. Madam, it is PDF, madam.
Yeah.
It is in a PDF format. What is it?
It is a PPT format, sir.
Yeah, could you please share the PPT, madam? PPT version.
This is the PPT, sir.
No, it is PPT, but it is converted into PDF version. But can you open PPT version, madam?
Okay.
Yeah. Did you got my point, madam, or not?
Yes, sir. Yes, sir. I'm doing that.
Yeah, please.
I don't ever slow up, no I don't take shit. I got no love.
Okay, sir. Actually, నా అకౌంట్ మీద వేరే అకౌంట్ ఇస్తాను అందువల్ల.
Always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over facts.
Madam, are you opening the PPT, madam?
Slow, speaking fast, I can roll,
Yes, sir.
I can gas, think
PPT
I'm all
doing
in
that,
last, but I don't know if that can
Please
erase all the
close this PDF and open that PPT.
Yes, sir.
You're with my time, you're delirious, mysterious, because you hide behind a fake exterior, inferior. You know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last, and to believe in what you got, it was built to last, yeah. Now that I've been put through hell, I never got anyone's help. I had to do it all myself. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Gonna learn the consequence of being incompetent. Mental health is confidence, dreams and some modestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead I say something not illogical, something that is topical. Rub it on and watch it go, make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable.
It is visible, but it is not. Slide change is not doing.
One second, madam. Control F. Press on F5, madam. F5. Button F5 is there.
Control F5.
No. Don't need a control. Just press F5.
What, sir?
Just press F5 button, madam. F5 button.
F.
Now that I've been put through hell,
Not F and 5. F5 is the button available in the keyboard.
Yeah, F5 I am pressing. It's not coming, sir.
Then you are in slideshow, right? From beginning, press on from beginning, madam. Top left side. Move your cursor to top left side. Yeah. Move your mouse to top left side. Left side. Madam. Hello. Madam, am I audible?
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness.
Madam, am I audible?
Play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up.
You are on mute, madam, I think.
I got no love
Kindly unmute.
for fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive, instant
Yeah.
passionate. Every word I move so descriptive, like
Tell
a
me, sir.
Now
adjective. I
share
call
the
it
screen, madam.
vendetta against people who patent it. Being
Yes,
negative
sir.
when you should be getting after it.
Your
I
screen
got
not visible.
facts over tracks, this and that, spitting slow, spitting fast. I could roast, I could gas, think I'm okay at last, but I don't know if that can
Is it
erase all the
visible, sir?
past and the pettiness.
Not yet, madam. Not yet.
Emptiness, hilarious. You think you're worth my time, you're delirious, mysterious, because you hide behind a fake exterior, inferior. You know I'll always be a bit superior. Get off of me.
Yes, visible, madam. Now you can open the PPT, madam.
Back, I want you to feel free from the chains that last, and to believe in
Yeah.
what you got. It was built to last.
Yes, madam. Go to the top menu bar, top side.
Menu bar.
No,
Yeah.
no, no. Here, below. From
Ah.
beginning. Click, press on from beginning. Yes.
Yes, sir.
Now press left side button or click from anywhere.
Then,
Press left arrow or right arrow.
yeah. It
Now
is
changing
coming.
the slide. Am I correct, madam?
Yeah. It is coming, sir?
Yes, it is changing the slide.
Yeah, yeah.
Now go to the back side. That is,
Yes.
so you are aware how to move left, right, next slide,
Yes, sir.
previous slide.
It,
Correct?
it is visible, sir?
It is very clearly visible, madam.
Yes, sir. Thank you, sir.
And the slides also changing.
Yes, sir. Thank you, sir.
Dreams are irresponsible, but they're always possible. If you just believe, you could be so
Yeah, you can turn off the screen share, madam. We will request, my team member will request you to turn off so that you can turn on the screen share. Okay?
Yes, sir.
Yeah, please stop the screen share and you can also meet it. Manisha?
Now that I've been put through hell, I never got anyone's help. I had to do it all myself. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play
Yes, sir.
and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
Good evening, everyone. I am Dr. Tilak. Thank you for joining the session. The thing is, I request everyone to mute your mics as well as video to save the bandwidth. Our resource person already joined in the meeting. So, before starting, I request Anisha to introduce the resource person to our participant. Thank you.
Good evening, everyone. It is my privilege to extend a warm welcome to our esteemed reserve person, Dr. Monalisa Pattanayak, a renowned expert in intellectual property rights and an inspiring research mentor. We are delighted to have you here to guide us through today's insightful session on intellectual property rights for researchers, patents, copyrights, and more. Your knowledge and experience in this domain will surely benefit all participants, especially researchers and academicians. We eagerly look forward to learning practical aspects of IPR that are crucial in today's research landscape. Thank you for joining us and accepting our invitation. Let us give a warm welcome to Dr. Mona Lisa Patnaik. Over to you, madam.
Very good afternoon, good evening to all my participants over here. I am Dr. Monalisa. I am going to speak on the topic. This is very burning topic and also very important topic for all the researchers. And I will say all the
Sir, just
researchers,
1 minute.
all the
Some
academicians.
person are
This is
continuously
very
disturbing.
important
Plus,
topic.
unmute him.
Intellectual property rights for researchers, patents, copyrights, and more. Yeah. Am I audible? Am I
Am I
audible?
audible?
Yes, ma'am.
Yes, ma'am. So,
Can I start
can I
now?
start?
Yeah.
Yeah.
Please turn off all our
So
mics.
this is the important
Please
topic. Intellectual
Intellectual
property
property
rights
rights
for
for
researchers,
researchers,
patents,
patents,
copyrights,
copyrights, and
my voice is
voice is
clear.
clear.
So this is all about my details.
Details.
I am
I am the
the head
head
of
of
the
the
department,
department,
Autonomous
Autonomous
Autonomous College,
College,
Kotak.
Pattanayak.
This is
This is
about
about
me.
me.
So
So,
agenda
agenda
of
of
today's
today's
lecture,
lecture,
introduction
introduction
to
to
intellectual
intellectual
property
property
rights,
rights,
IPR
IPR
for
for
researchers, patent for researchers, copyright in research and publications, protecting and commercializing research output, recent trends, policies, and legal consideration, conclusion and key takeaways. Yeah. So, what is the meaning of intellect? Intellect means the person's mental powers. Intellect is the capacity for thinking and acquiring knowledge, particularly of a high or complex order. It involves reasoning, understanding abstract concepts, and applying logic. So, intellectual property rights first is
first is
forming
forming
the
the
intellect.
intellect.
Okay,
Okay,
so it
so
is
it is
the person's
the
mental
person's
power. Intellect encompasses various cognitive abilities such
such
as memory,
as
problem
memory.
in critical thinking, research, and reflection about the society's issues and proposes solution for the normative problems of the society. So,
So,
intellectual
intellectual
meaning
meaning,
it
it
is
is
related
related
to
to
intellect.
intellect. I'm
Already
already
told
told
intellectual
intellectual
refers
refers
to
to
the
the
person
person
who
who
will
will
engage
engage
in
in
the
the
critical
critical
thinking,
thinking,
research,
research,
and
and reflection
reflection
about
about
society's
society's
issues,
issues,
proposes
proposes
solution
solution
for
for the
the
normative
normative
problems
problems
of
of
the
the
society.
society.
Intellectuals
Intellectuals
Hello,
are
are
excuse
often
me.
often
involved
involved
in
in
Hello,
activities
activities
such
such
as
as
yeah, yeah.
hello.
eco.
Can you please mute one device
Yeah.
because
Yeah,
there is echo.
Yes, sir.
yes, sir.
Thank you, ma'am.
Yeah.
Yeah,
Yeah.
yeah.
So
So,
intellectual
intellectual
meaning
meaning
it
it
is
is
the
the
person
person
who
who
engages
engages
in
in
critical
critical
thinking,
thinking,
research,
research,
and
and
reflection
reflection
about
about
society's
society's
issues.
issues.
Okay.
Again,
Again,
problem of
yes.
Madam, can you turn off the another account, ma'am? Mic.
Yes,
yes,
sir.
sir.
Is
Is
it
it
Now
clear?
it's okay, ma'am. No, ma'am. Again, echo is there.
Okay, ma'am. Okay.
Again, I am rejoined. Hello. Is it audible, sir? And my screen is visible, sir?
Yes, ma'am.
Yes, sir.
Yes, now all good.
Yes, sir. So I'll start. Sometime the screen is problem. I don't know why. Yeah. Again, it is problem, sir.
Please share the PPT, ma'am. I
Yeah.
don't. Okay. Okay. From the
It is not
beginning.
changing,
Please
sir.
select.
It is not changing
Okay. Okay. From beginning, ma'am. Please select from beginning.
from beginning. Yeah.
Please select from beginning, ma'am. Your PPT is not visible, ma'am. Please share the PPT, ma'am. Okay, ma'am. Please from beginning, ma'am. Please select from beginning.
Yes, sir. Yes, sir. It is not again coming, sir. How to do, sir?
Please cursor the from beginning, ma'am.
Yeah. Yeah, it is visible, sir.
No, no, ma'am.
Slide change is happening, but
Yes, ma'am. From beginning, ma'am. From beginning.
from beginning it
Yes,
is
ma'am.
seeing, sir.
Please select, ma'am. I don't.
Yes, sir.
It is not visible, ma'am. Please select it from beginning.
Yeah, I'm selecting that.
PPT is not visible, ma'am.
Yes, sir. Yes. It is coming, sir.
No,
Yes, ma'am. You can start, ma'am.
you can
Okay.
start, ma'am.
So this is the topic: intellectual property rights, IPR for researchers, patents, copyrights, and more. I am Dr. Monalisa, head of the department MBA, Sarabala Women's Autonomous College, Cuttack, Odisha. This is all about me. So today's agenda from introduction to conclusion. So intellect is the person's mental power. Intellect refers to mainly the capacity for thinking and acquiring knowledge, particularly of a high or complex order. It involves reasoning, understanding abstract concept and applying the logic. We are applying our logic and we are understanding the abstract concept, and we are applying the reasoning. We are thinking something new, something innovative. That is intellect. Intellect encompasses various cognitive abilities such as memory, problem solving skill, and the capacity to comprehend intricate ideas and theories. So, in essence, intellect is all about cognitive ability to think and understand. Cognitive word comes from the word cognition. Cognition का मतलब means अंतर्ज्ञान होता है, inner ability to think and understand. That is intellect. What is intellectual? Intellectual is related to the intellect. Intellectual refers to a person who engages in critical thinking, research, and reflection about society's issues and proposes solutions for the normative problems of the society. So, that is the persons who will engage in all this critical thinking, research, and all. Intellectuals are often involved in activities such as writing, teaching, speaking, and they can contribute to the development of ideas in various fields like philosophy, like science, literature, and politics. An intellectual is typically characterized by a deep engagement with ideas and a commitment to using their knowledge to influence or understand the world. So, intellectual person will engage in all the activities, research activities, deep engagement, critical thinking with new ideas and a commitment to using their knowledge to influence or understand the world. So, in essence, we can say an intellectual is about the application of the cognitive ability in societal and academic context. So, intellectual property rights will have the property. What is the meaning of property? Property refers to anything that is owned by an individual or entity encompassing both tangible and intangible assets. So, types of property including there are several types of properties: real property, personal property, intellectual property, public property, and private property. So personal property can be both tangible personal property and intangible personal property. So tangible personal property can be the physical items such as vehicles, furniture and jewelry, whereas intangible personal property that may be the non-physical assets such as stocks, bonds, patents, copyrights. Okay. So we are talking about the intangible personal property. That is the patent, copyright, trademark, trade secret, that is our personal property. So as a owner, we will have the legal right for this property. So nobody can copy paste our idea or they cannot manipulate our ideas, okay, which is our own. So they are our personal properties: patents, copyrights, trademark, trade secret, geographical indications. Okay, so intellectual property, that is the creation of mind such as inventions, literary and artistic works, symbols, names, and images used in commerce. Okay, so intellectual property is related to our human mind. That is the creation of human mind such as inventions, literary and artistic works. Literary and artistic work may be some literary writing or some musical work, music album. That is our intellectual property. That is our creation of mind. Or we are using some symbols, names, images. Okay, these we can protect. That is intellectual property. That may include the patents, trademarks, and copyrights. These are all the types of IPR. Okay, intellectual property rights, which are the creation of our human mind. This is our own intellectual property that we can that nobody can manipulate without our permission, because we will be the owner of that property. Public property assets owned by owned by government, federal, state, and local for public use, such as parks, roads, and public buildings. These are public property. These will be, means this property will be used by the public, all for public use. Parks, roads, public building, all we can use. So private property owned by individuals or corporations, not by government or the public. This includes home, cars, personal belongings.
Excuse me,
So
ma'am.
in terms, property
Hello,
can be the
excuse me,
bundle
ma'am.
of rights. Yes, yes, sir.
Ma'am, sorry to interrupt you, ma'am. Actually, slides are not changing.
Changing. I
No,
am
no,
telling the types of property, sir, now.
ma'am. We are only seeing. We are able to see only first slide only.
First slide.
Only we are able to see only first slide.
Oh, yes, sir, yes, sir. Let me. Again, it is problem, sir. What is the problem? I don't
Now,
know.
ma'am, we can see what is intellectual. We can see what is intellectual.
Yeah, yeah, yes, sir, yes, sir. I'll share it again. Sir, it is visible, sir,
Yeah,
but it
ma'am.
is
Now
not
we can
changing.
see what is property.
Yeah.
Ma'am, on the downside, where 81% is given,
Yes.
there you can put cursor on the this slide mode.
Uh,
This
ma'am, no,
box.
Slide.
This
ma'am, ma'am,
box.
we can do click F5, ma'am. Click F5.
F5
F5.
from F5.
F5.
F5, it is not coming in my laptop.
It, then
Oh,
move the cursor a little bit down, ma'am. There is a uh,
a tray is there.
tray. Move the arrow down, ma'am.
Down, down.
Down, more down, ma'am. There,
On the right side, ma'am. Right side.
right side.
More right. Yeah, that's left to the just to the this tray.
Down,
This
ma'am.
box. Yes, down.
This?
No, ma'am. This box is there, na. This a box adjacent to this book symbol. It is a symbol of book
Yes,
on
sir.
the downside.
Yes, sir, again. Book style. Yeah.
In the
It is
in
coming,
just
sir.
no, ma'am.
Now I am sharing, sir. Sir, it is coming.
What is property? Yes, ma'am. It is
Ma'am,
very
But
okay.
it is not moving, sir. That is the problem, sir.
now, no, ma'am. Now click down arrow or left
Arrow.
arrow, right arrow.
Page down and page up I am doing, sir.
No, not that, ma'am. Down. There is
Arrow.
down arrow, left arrow next to control.
Next to control.
Right
Down
side,
arrow.
right side, next to the numbers. Down arrow, up arrow, left arrow, right arrow.
No, sir, not possible, sir. It is not coming.
Okay, click page up and page down, ma'am. Let's see.
Page up, page down, it is not coming.
It is not coming. Uh,
If you want PPT, I will share in the comment section. Please check it the link. Okay, ma'am. Please
Sir,
continue
you
the
are
ma'am.
sharing?
I will share all. I will just share the PPT, ma'am, in comment section. Okay.
wait a minute.
Yeah.
Scroll
Please
down, ma'am.
continue the class, ma'am.
Again, it is not coming, sir. What is the problem? I don't know.
Ma'am, scroll up, scroll down.
Scroll up, scroll down, also not coming, sir.
Hello. Hello.
Is it feasible? That time it
Madam, I
happened.
already shared the PPT, so it is not a problem. So you continue the class, ma'am.
Hello, sir.
Madam, please continue the class, ma'am. I will already share the PPT directly in comment section, so it is not a problem. So please continue the class, ma'am.
Okay, sir. Okay. ठीक है. ठीक. So, rights are the legal, social, or ethical principles of freedom or entitlement. That is, rights are the fundamental normative rules about what is allowed people or owed to people according to some legal system, social convention, or ethical theory. So, rights are some persons' legal principles of freedom or entitlement. That is legal. That is the own right or own freedom. What is intellectual property or IP? Definition. It is audible, sir?
Yes, ma'am. Yes, ma'am.
Yes.
It is
Yes,
all.
ma'am.
Thank you. So IP refers to the creation of minds such as inventions, literary works, symbols, and design. So we can protect our ideas, whatever our ideas that is from our mind, human mind. We are have, having some inventions that may be literary work, that may be some symbols we created new, and some designs we created new, that we can protect. That is, intellectual property is the creation of mind. Purpose: provide legal protection and encourages innovation by granting exclusive rights. So, who is the owner of the invention or creation? The owner have the legal protection, and they will provide the legal protection. Purpose is to legally protect their ideas, and intellectual property that will encourage innovation by granting exclusive right. So the persons will have the exclusive right, their own separate rights, by granting some exclusive right. So nobody can copy paste your our own idea. Who is the owner or who is the creator of the property? So nobody can copy paste or manipulate the owner's idea. So introduction to intellectual property rights, IPR. So IPR are the legal rights that protect creation of mind, granting creators exclusive rights to their work for the certain period. So we will have the types of IPS like patents, copyrights, trademark, and trade secret that will have some certain time period. So we can protect our ideas to that limited time period. So intellectual property rights (IPR) are the legal rights that will protect the creation of human mind, granting the creators or owners the exclusive right to their work for a period. So these rights such as patents, copyrights, trademark, and trade secrets encourage innovation by providing creators or owners with incentives. So from this we can, as an owner, we can also get some incentive to develop new ideas and inventions. Okay. So IPR also increase economic growth by allowing the creators and the owners to benefit from their creations and promoting the fair competition. So we'll also benefit from our creation. We can sell our ideas. We can promote our ideas. Okay. So IPR will foster all that will increase the economic growth. तो इंटेलेक्चुअल प्रॉपर्टी राइट्स फॉर रिसर्चर्स. सो रिसर्चर्स के लिए क्या इंपॉर्टेंट है intellectual property? So we will get to know. So intellectual property rights here in research are very very important. These are the legal rights granted to the researchers and the institutions for their original creations. So whatever our creation, that will be original creation, that will be new or innovative creation, new or novel creations, inventions and discoveries, protecting the owner from unauthorized use, reproduction or distribution. So no other person can use that. So that will be whatever our creation, that will be intellectual property right will protect them from unauthorized use, reproduction or distribution of our own idea. These rights are crucial or important for fostering innovation, encouraging investment in research, and ensuring fair competition. So, intellectual property rights are very, very important for increasing our innovation, encouraging the investment in research. As a researcher or as a research scholar, we can encourage investment in research. More and more research we can do. We can increase the innovation and ensuring the fair competition. Key aspects of IPR. So, first is protection of intangible creations. IPR will safeguard creation of mind, including inventions, literary and artistic works, symbols, and designs used in commerce. So, IPR will protect our creation of mind, including our own invention. It will protect our ideas. That may be our literary work, that may be our artistic work, or some symbols or design we created. Okay, so protection of intangible creation. Then second is exclusive rights. IPR grants creators exclusive right to use, reproduce, and distribute their creations, preventing unauthorized use by others. So intellectual property rights will grant the creators or the owners exclusive right to use, reproduce, and distribute their own creation. So, the owner, they can use, reproduce, or distribute their ideas or creation. So, nobody can use or reproduce or distribute our creations or the owner's creations without the permission. So that will IPR will preventing unauthorized use by others. That is the exclusive rights or that is the legal rights that will be given to the owner or creator to protect their own ideas. Okay. So encouragement of innovation by providing creators with legal protection and potential economic benefits. IPR will incentivize individuals and companies to invest in research, development, and creative endeavors. So that IPR will encourage the innovation. So who are the creators? Who are the owners of the idea? So IPR will legally protect our idea and that will give us the economic benefits. That will incentivize us, that maybe individuals and companies to invest in research, development, and creative endeavors. We can invest in our research, so we can get that incentive. Economic growth. IPR will increase economic growth by promoting innovation, allowing creators to benefit from their work and encouraging competition. So IPR will increase the economic growth by promoting our innovation and promoting the creators and allowing the creators to benefit from their work. So as a creator or as a owner of our work, we can also sell our product, we can distribute our product, we can reproduce, sell, and distribute our products. So we can benefit from our work. So no other person can copy paste our own idea. So IPR will help us to increase our economic growth. So types of IPR. IPR includes mainly four things: patents, copyrights, trademarks, and trade secrets. Patent will protect our inventions, our new idea invention that will protect. Patent protect the inventions. Copyright, that is for, that will protect our literary and artistic works. Some literary writing may be there, some poem may be there. Okay, some artistic work, maybe some music album, we can protect our ideas. Trademarks for brand identification. Trademark also brand identification. We are using logos, symbols, names. So one particular brand's logo is different from another brand, so that is a trademark. Suppose, for example, uh, Adidas shoe logo is different from Puma or Nike. That is the trademark. Suppose, for example, some soft drink brand, Coca-Cola, Thumbs Up, Limca, maybe Sprite. Okay, so logo will be different so that we can identify the particular brand. Symbol, sign, logo, names, we can identify the particular brand product. That may be soft drink product, that may be the shoe product, shoe brand, that may be automobile brand. Okay, we can identify easily the brand products. Trade secret, that is for confidential business information. So whatever our business ideas, that we should be protect from others, that we should keep confidential, that we should not disclose our ideas to others, that should be confidential. Suppose I am good at making Shahi Paneer. So I will not disclose my idea to another person. That is very much confidential to me. That is my own trade secret. Suppose Domino's Pizza or like uh, McDonald's pizza. Okay. So that is also confidential business. That is the secret of that pizza. So no other brand will copy paste the idea. That is very much confidential to us, to that brand. Suppose, for example, Coca-Cola. Coca-Cola, what is the formula it is using, and what is the taste, that will be unique. That is the confidential of that Coca-Cola. So no other brand can copy paste that idea. That is the trade secret of that Coca-Cola product. That is the soft drink product. So intellectual property can be patent, can be trademark, trade secret, copyright, industrial design, geographical indications, layout design, plant varieties. Oh, these are some of the invention, innovative idea. So we can protect it through the intellectual property rights. So patent is the exclusive rights granted for an invention. Whatever invention we are doing, as an owner or as a creator of our own idea, the owners will have granted the exclusive right or separate right. That is the legal right provided to the creator or owner for their work. Protect new inventions, granting the patent holder exclusive right to use, make, sell, and distribute the invention. So patent holder, who are the patent holder, they can protect their new invention, granting the who is the patent holder, they will have the exclusive right to use, make, sell, and distribute the invention. So as the owner, they can use, make, sell, and distribute their invention. So no other person can copy paste the person's idea without his or her prior permission. They cannot copy paste or they cannot use, make, sell, and distribute the invention of the patent holder. So patent mainly duration is 20 years. So from the filing date of the patent, we can protect it up to 20 years. So duration is 20 years. Criteria: novelty, inventiveness, industrial application. So whatever the patent, the criteria should be novelty, inventiveness, and industrial application. Whatever the patent we are doing, whatever the new inventions we are doing, that invention or creation should be novel, new. Inventiveness, we should get benefit out of it. Inventiveness, and that should have new invention oriented, novel, new, and it should have some industrial application. Okay. So these are some of the criteria for the patent. Types of patents include utility patents, design patents, and plant patents. Utility patents for new and useful processes, machines, and composition of matter. Design patents for new, original, and ornamental designs. Some aesthetic design, ornamental design, that is design patents we are using. So plant patent for new and distinct plant varieties. So plant patents should be new and distinct plant varieties. That will be distinct means some different plant variety we are using. That we can protect our idea. So who is the patent holder? They will have the exclusive right granted for their invention. That may be utility patent, design patent, or plant patent. So for example, mobile technology, pharmaceuticals, we can have our new invention or new ideas. We can protect it through the patent. Some more example we will discuss. Edison's light bulb, that is inventor is Thomas Edison. So we can protect this patent. Okay, Edison's light bulb, that is the patent example. We can protect the idea. The patent holder will have the exclusive right for the creation. That is the light bulb. Similarly, CRISPR gene editing technology, that is the US patent. Okay, inventor is Jennifer Doudna and Emmanuel Carpenter. So we can also protect this idea in the patent. We can also protect this idea from filing date to up to 20 years from the filing date. Apple's multi-touch interface, that is also patent. Apple's iPhone, iPad, we are using the devices, that is also the patent idea. We can protect it up to 20 years from the date of filing. Copyright protects original, literary, artistic, and musical works. Whatever our idea, that may be in the musical form, in the artistic form, or in the literary work, literature writing. Okay, musical album. Okay, the creator will have the exclusive right to reproduce, distribute, and perform, display, and create the derivative works. So, as the owner, we can have that right. That is, we can have the exclusive right to reproduce, distribute, perform, and display, and create the derivative works. We have that right, exclusive right. Copyright typically lasts for lifetime of the creator plus an additional 50 to 70 years depending on the jurisdiction. So duration may be life of the author plus 60 years in India. So creator will have additional 50 to 70 years time period. They can protect the copyright. Okay. So copyright includes literary works, music, films, paintings, photographs, softwares, that may be databases, architectural designs. Copyright will protect only expression, not the ideas. Whatever the ideas, we can protect it. That will protect the expression, not ideas. So for example, books, films, music, and software. So these are all the copyright examples. Books are some literary works, films are some artistic work, music also musical work, software work. These are all the original work which we can protect through copyright. Some other example, maybe we can take more example. Harry Potter's book series, that is also books. Thriller by Michael Jackson. Okay, this is the iconic songs, like there are some iconic songs like Billie Jean, Beat It. So Thriller by Michael Jackson. This is all the related to music. Star Wars films. This is related to films. So our ideas we can protect through copyright. Our original idea or work we can protect through copyright. That duration is the additional 50 to 70 years. Lifetime of the creator plus an additional 50 to 70 years we can protect the copyright. Then trademark. Trademark distinguishes goods or services with a symbol, name, word or logo. So we can identify the products, brand products through the symbol, name, word or logo. We can take the example of soft drink brand, some soap brand, and also the automobiles shoe brand. Okay. Trademark distinguishes goods or services with a symbol, name, word or logo. So trademark will protect symbols, names, slogans or logos and other identifiers that will distinguish the goods or services. So trademark that can last indefinitely as long as the trademark is in use and properly maintained through renewals. Okay. Trademark this can last indefinitely. Renewable every 10 years duration that can be renewable. For example, like shoes, Coca-Cola logo, they can be protected, they can be renewed every 10 years. So trademark also includes some service marks, collective marks, certification marks. Okay. Service marks including the identifying the services, collective marks indicating the membership in an organization, and certification marks certifying the origin, material, mode of manufacture, quality and other specific features of goods or services. So we can have three type of trademarks: service marks, collective marks and certification marks. So some more example of trademarks: Coca-Cola. कोकोकोला के ऊपर एक आर में स्मॉल सर्कल जैसा है, दैट इज क्या ऑलरेडी रजिस्टर्ड प्रोडक्ट कोकोकोला. So Coca-Cola trademark includes the distinctive script logo and the contour bottle design. So logo will be different from another brand product and the contour bottle design is also different from another soft drink product. This trademark is one of the most recognized in the world. कोको कोला के ऊपर जो आर का साइन है जो सर्कल में है, that is capital R. This trademark is one of the most recognized in the world, representing the Coca-Cola company and its beverage products, registered by the Coca-Cola company. So significance, it distinguishes Coca-Cola products from other beverages, ensuring brand identity and consumer recognition. Consumer will easily recognize the product from other brand products. Similarly, Nike shoes के ऊपर एक R में small circle जैसा है, that is written in within circle capital R. That is Nike shoes is a simple curved check mark that represents the Nike Inc. and its products, including footwear, apparel, and sporting goods, registered by Nike Inc. The shoes is instantly recognizable and conveys the brand's association with athleticism, performance, and quality. Similarly, Apple logo के ऊपर small circle में एक capital R लिखा गया है. That is the Apple logo is a stylized apple with a bite taken out of it. Okay, you can see in the Apple logo. This logo represents Apple Inc. and its wide range of products, including computers, smartphones, and software. So that logo will be different from another brand. So registered by Apple Inc., the logo symbolizes innovation, design, high quality consumer electronics, making it one of the most iconic trademarks in the technology industry. So trade secret will have some business information. We can means not we will not disclose our idea. That should be confidential. That may include some formulas, practices, designs, process. That may be some recipe ideas, some proprietary methods. So protection lasts as long as the information remain confidential and provides a competitive advantage. So trade secrets will be our own trade secret or business information that should be confidential, and as long as we protect it, that can be protected. Okay. So Coca-Cola formula, trade secret example, Coca-Cola formula, Google algorithm. So these are some confidential business informations which are the confidential informations which can be protected through trade secrets. Some examples, Coca-Cola formula, then Google search algorithm, KFC's original recipe. These are the examples of trademark. So trademark may we will protect our business information, our confidential business information, we can protect it. Then geographical indication, GIS. So specific geographic area wise we can protect our product. Suppose for example Darjeeling tea. In that region Darjeeling, the tea is famous, Darjeeling tea. That is also coming under the IPR, intellectual property rights. So that tea is popular in Darjeeling, so we can protect the tea product from that particular region. So we can protect that product, Darjeeling tree. Then Banarasi sari, then Basmati rice. So as per the particular region, we can protect the ideas. So geographical indications, in short GIS, that identifies products from specific regions with unique qualities. So with that particular region, the product will be highly popular. Okay. So from specific region, the products are having unique qualities, very popular. So more example can be champagne, sparkling wine, champagne from France. That is also GIS, geographical indications. Example, Darjeeling tea from West Bengal. Darjeeling tea is mainly the type of black tea grown and processed in Darjeeling district of India and known for its distinctive aroma and flavor, and it is often referred to as the champagne of teas. So GI के स्टेटस भी लगा है उसमें दार्जिलिंग टी में, जो कि region is West Bengal, India, that will protect the unique characteristics and reputation of Darjeeling tea, ensuring that only tea produced in this specific region can be labeled as Darjeeling tea. So the GI status also protect the unique characteristics of that tea. Then Roquefort cheese from France. So that is the blue cheese made from sheep's milk and aged in the natural caves of Roquefort Solgen in France. The cheese is known for its tangy flavor and creamy texture. That is also we can having some GI status to ensure that only cheese is produced in this region, that is France, using some traditional methods can be called Roquefort, preserving its unique qualities and heritage. So it is having the GI status. Then industrial design, and that will protect the aesthetic or ornamental aspects of the object, grant protection for the appearance, shape and pattern and color of the product. That can we protect, that can last for 10 to 25 years depending on the jurisdiction. For example, Coca-Cola contour bottle. So Coca-Cola के iconic जो bottle होता है, जो that will be different from other brand, soft drink brand. So that is its own unique industrial design. For example, Apple iPhone design, that will be different or unique from other iPhone brand. Then Vespa scooter. The scooter brand is having distinctive design, so it will be very much different from other scooter brand. Then plant breeders' right, that is in short PBR, that will protect new varieties of plant that are distinct, uniform and stable. Grant breeders exclusive right to produce, sell and distribute the new variety. Whatever the new variety plant, the owner should produce, sell and distribute the new variety plant. That can we protect up to 20 to 25 years depending on the plant species and jurisdiction. For example, honey crisp apple. From breeder is from University of Minnesota. Okay, so Honeycrisp apple is very uh, known apple variety. Okay, so we can protect it through plant breeders' right. Then Songold kiwi. That is Songold is the variety of kiwi fruit with yellow flesh, smooth skin, and a sweet tropical flavor. So that brand we can also protect through plant breeders' right. And Envy apple. Breeder is hot research. Now plant and food research in New Zealand. NB apple is the hybrid between the Brabant and Royal Kala varieties. Is known for its sweet flavor, crisp texture, and slow browning when caught. So that is the variety, different variety plant breeder right के थ्रू हम प्रोटेक्ट कर सकते हैं दिस ब्रीडर वेराइटी को इन बी एप्पल को. So this is all biotechnology research na. Sungold kiwi, NB apple, horticulture research or some plant variety, plant breeders' rights, we can protect it. Yeah, also research is going na in the plant varieties. बायोटेक्नोलॉजी रिसर्च में बहुत सारा रिसर्च किया जाता है ना इसमें. तो बायोटेक रिसर्चर्स आल्सो प्रोटेक्ट द plant breeders from the new plant varieties from this plant breeders rights. Integrated circuit layout designs protect the three-dimensional configuration of electronic circuits used in microchips and semiconductor chips. Then grant exclusive right to reproduce, manufacture and sell the layout designs. Whatever the new design, the owner will have the exclusive right to reproduce, manufacture and sell the layout designs. Protection typically lasts from 10 years from the date of creation or first commercial exploitation. For example, digital CMOS circuit layout, okay, that we can protect through integrated circuit layout design. That is the type of IPR. Analog IC layout, for example, operational amplifier, mixed signal IC layout, for example, analog to digital converter ADC, we can protect it through this integrated circuit layout designs. These are all the types of IPR. So types of intellectual property rights, that is IPR, in research that include the patents. Patent I already told, copyright, trademarks, trade secrets, industrial design. Industrial design protect the aesthetic or ornamental aspect of products such as its shape or configuration. Plant variety protection protects new variety of plants, giving the breeder exclusive right to produce, sell and distribute the plant. Then geographical indications protect products that originate from specific geographical location and possess qualities or reputation linked to that location. So as per the particular location, the product will origin, we can protect it through using the GIE status, we can protect the products. Examples of IPR in action: pharmaceutical company can patent a new drug to protect its investment in research and development. An author can copyright their novel or new ideas, preventing others from copying or distributing it without the prior permission. So whatever the copyright of our new idea, the author can prevent others from copying and distributing it without the prior permission of that author. So business can trademark its logo to distinguish its products or services from competitors. A company can protect its trade secrets such as unique recipe or manufacturing process from being disclosed to rivals. So we will not disclose our idea, that should be confidential, that is trade secret. So whatever the business secret or business information, that is the trade secret, we can protect it through the trade secret, that is the type of IPR. Importance of IPR: IPR will promote the innovation. IPR provides a framework for innovation by granting creators exclusive right to their creation, enabling them to benefit from their efforts. IPR will protect the creators' right. IPR ensures that creators are recognized and rewarded for their intellectual contributions, encouraging further creativity and innovation. So IPR will protect the creators' rights. IPR will facilitate economic growth by encouraging innovation and protecting intellectual property. IPR also contribute to economic growth and development. So IPR will facilitate the economic growth that will increase the innovation and protecting the intellectual property that can contribute to economic growth and development. IPR can balance interest. IPR strike a balance between protecting the rights of creators and ensuring that public has access to new idea and creations. इम्पोर्टेंस ऑफ आईपीआर इन रिसर्च. सो रिसर्च में आईपीआर का बहुत इम्पोर्टेंस होता है. आईपीआर विल एनकरेज द इनोवेशन. आईपीआर प्रोवाइड क्रिएटर्स with exclusive right, incentivizing them to invest time and resources in research and development, knowing their work will be protected. So whatever the work we are doing, our new inventions, creations, we can have the exclusive right as a owner, as the creator. We can having the exclusive right to incentivize from them to invest time and resources in research and development, knowing our work will be protected. Promotes dissemination of knowledge. IPR will grant exclusive right. They also encourage the disclosure of new knowledge to the public, and inventors are often motivated to share their work in exchange of for protection. So IPR will promote the dissemination of knowledge. IPR will facilitate the technology transfer. IPRs will enable the transfer of technology through licensing and other mechanisms, allowing research findings to be commercialized. And so as a researcher, we can having some research ideas, some research findings, we can be sell it. That can be for commercialization purpose, and we can that can be used for the benefit of the society. So IPR facilitates the technology transfer to licensing the product and allowing the research findings to be commercialized and used for the benefit of the society. Then supports economic growth. IPRs will contribute to economic growth by fostering or encouraging innovation, creating new industries, and promoting fair competition. So IPR will contribute the economic growth by increasing the innovation. We will have some innovative ideas, new ideas. We can create new industries. We can promote the fair competition. So IPR will support the economic growth. Enable funding. Research institutions and researchers can use IPRs to attract funding for further research and development by demonstrating the potential for commercialization. We can use our idea and we can protect our idea. We can sell it. So that can be for commercialization purpose. And we can get the return on investment. So IPR creates competitive advantage. Securing IPRs can provide a competitive edge for research institutions and companies, allowing them to commercialize their innovations and gain market share. So research institution and company also gaining some competitive edge. They can commercialize the innovations and gain the market share, and reduces duplication of effort. So IPR help the researchers to avoid investing in research that has already been done and protected, and allowing them to focus on new and innovative areas. So no other researchers can copy paste the original work of the researcher. Okay. So IPRs help researchers avoid investing in research that has already been done, already been published. Okay, and that will help in protection, allowing the researchers to focus on new and innovative areas. So IPR laws in India, there are various intellectual property right laws in India. Patents Act 1970, amended in 2005, Copyrights Act 1957, Trademarks Act 1999, Designs Act 2000, Geographical Indications of Goods Act, that is 1999. So these are some of the IPR laws. And year wise it is written. We can remember year wise. Patents Act 1970, Copyrights Act 1957. We can just remember it. The international treaties, we, that is World Intellectual Property Organizations. That is the full form. TRIPS Agreement, Paris Convention, Berne Convention. These are all the international treaties. Then challenges in IPR, intellectual property rights. There are some benefits, also some challenges we are facing in IPR. That is piracy and counterfeiting, enforcement issues, high cost of international filing, balancing public versus private rights. So there are some challenges we are also facing in IPR. Piracy means some theft. Okay, some theft and so that is the challenge in IPR. Counterfeiting is also some नकली चीज बनाना, some fake चीज बनाना, नकल करना और जाली बनाना, that is counterfeiting. That is also challenges in IPR. Enforcement means some supervision or monitoring issues also that we are facing in challenges in IPR. High cost in international filing, that is also challenges. Balancing public versus private rights also challenges in IPR. Careers and opportunities in IPR. We can also do the career in IPR. So patent analyst, IP lawyer or consultant, IP manager in R&D, research and development, policy analyst, entrepreneurs using IP for strategy. We can also do the career in IPR. Conclusion, summary. In conclusion, intellectual property rights play a crucial role in research by incentivizing innovation, protecting creators' right, promoting the dissemination of knowledge, and fostering the economic growth. So, intellectual property right is important to address the challenges associated with the IPR, such as balancing rights with public access and ensuring ethical consideration are taken into account. So, it is important to address the challenges associated with the IPR, such as balancing right with the public access and ensuring ethical considerations are taken into account. Researchers and institutions need to be aware of IPRs and their implications to effectively manage and protect their research outputs. Challenges and consideration, balancing rights with public access, open access movement, international cooperation. IPR can protect IPR protection can be complex, especially in the context of international research collaboration, requiring careful consideration of different legal frameworks and enforcement mechanisms. Ethical consideration, IPR in research can raise ethical consideration, particularly in areas like biotechnology and human health, where research findings may have significant social and ethical implications. So there are some challenges and consideration. We as a researcher, we should keep in mind there we will face some challenges and consideration. IPR in research can raise ethical consideration, particularly in areas like biotechnology and human health, where research findings may have significant social and ethical implications. Enforcing IPR can be challenging, particularly in developing countries, requiring effective legal frameworks and enforcement mechanisms. Patent for researchers. Patent offer researchers exclusive right to their inventions for a set of period that is 20 years, preventing other from making, selling, using the invention. So no other person can copy paste the patent holder's idea. So patent holder will have the exclusive right or separate right to protect their idea from date of filing of the patent to up to 20 years. For researchers, securing a patent can be crucial, important, or vital for establishing themselves as innovators, protecting their intellectual property, and potentially generating revenue from their work. So, we as a patent holder, we can protect our intellectual property and we can generate the revenue. We can make the profit out of our work. We can sell, we can distribute our product. We can sell, make, use the product. Okay, so that is for revenue generation purpose. We can generate revenue from our work as a patent holder. Breakdown of key aspects of patents for researchers. What is a patent? Patent is a legal right granted by a government that allow the inventor to exclude other from making, using, or selling their invention. So no other person can make, use, and sell our own invention. It is a form of intellectual property protection similar to copyrights or trademarks, but specifically for inventions. So it is like similar to copyright or trademark. It is a form of intellectual property protection. Patents are territorial, meaning they only protect within the country where they are granted. That is territorial. So there are three types of patents: utility patents, design patents, and plant patents. Utility patents will protect the functional aspects of the invention, such as process, machine, manufacture, or composition of matter. Design patents can protect the ornamental design of the article, aesthetic design of the article. Plant patents can protect the new varieties of plants. Okay, there are three different types of patents: utility patent, design patent, and plant patents. Okay, we can protect our patents through the intellectual property rights. This is the type of IPR patent. Utility patent example: machines, process, compositions, improvements. Machine example: 3D printers, robots. Process example: software algorithms, manufacturing methods. Then composition example: pharmaceutical products, drugs. So these are all the utility patents. Improvements including enhanced battery life, more efficient engines. Then more examples of utility patents: Amazon's one-click ordering system, Google search algorithm. Okay, these are all the utility patents. Apple's touchscreen technology, medical device, for example, pacemakers, insulin pump. Then renewable energy technology, for example, solar panels and wind turbines. So utility patent will cover functional aspects of the invention, provide the exclusive right to the inventor or the creator for a specified period, that is usually 20 years from the date of filing of that patent, utility patent. Design patent example: design patent protect the ornamental design or visual appearance of the product. For example, product shape. Example, Coca-Cola's bottle design. That will be different from another beverage product or soft drink product. That shape-wise different, design-wise different. Graphical user interface, that is GUIS. That is also coming under the design patents. Graphical user interface, icon and symbols, that will be different from other brand products. Easily identify the products, that is design patent. Example, furniture design, for example, chair shapes, table designs, jewelry designs, packaging packaging designs, for example, bottle caps, label designs. Design patent will focus on the visual aspects of the product rather than the functional aspects. So by seeing the visual aspects of the product, we can easily identify the product. Okay, so they can help prevent others from creating similar designs that could confuse consumers. Okay, So we can take also various examples of design pattern. Apple's iPhone design, Nike's shoe design. So Nike's shoe design will be different from another. That may be Puma or Adidas. Luxury car design, example Ferrari, Lamborghini. So the design may be vary, that may be different. Okay, that is the design pattern example. Design pattern provide exclusive right to the design owner for a specified period, that is usually 14 to 15 years from the date of filing of that patent. Plant patent examples. Plant patent protect new and distinct varieties of plants such as roses, fruit trees, for example, apples, oranges, grapevines, ornamental plants. Okay. So plant patent cover the invention of new plant varieties, including new traits, for example, disease resistance, uh, then drought tolerance plant, then unique characteristics, for example, flower, color, fruit size. That will be unique characteristic wise. We can also identify the plant varieties. And that is the plant patent example. Example of plant patents also, there are new rose varieties with unique colors of fragrances, disease resistant grapevines for wine production, breadfruit trees for compact growing species. So plant patent provide exclusive right to the patent holder for 20 years, allowing them to control the propagation and sale of the patented plant variety. So plant patent को हम लोग 20 years तक हम उसको प्रोटेक्ट कर सकते. Eligibility for patents, what should be the eligibility for the patent? The patent should be novel or new, that should not be previously known or used in public. Non-obviousness, the invention should not be obvious or clear to someone with ordinary skill in the relevant technical field. Okay, so that should not be obvious, clear to someone. Utility, the invention must have practical use or application. Whatever utility, whatever the patent we are doing, our invention, that should have, must have some practical use and application. Patentable subject matter, what can be patented? Ideas and theories that can generally not patentable, they cannot be patentable. Ideas or theories, they cannot be patentable, but specific applications, processes, tangible inventions derived from research may be patented. So patentable subject matter means what can be patented. Applications, process and tangible inventions derived from research can be patented, but ideas and theories cannot be patented. Why are patents important for researchers? So patent क्यों important है researchers के लिए? Protection of intellectual property. Patent will safeguard researchers' invention from unauthorized use and replication, so no other person can replicate or unauthorized use of the patent holder's idea. Okay, patent will safeguard researchers' invention from unauthorized use and replication, so no other person can unauthorized use and replicate the idea of the original work of the patent holder or researcher. Commercialization opportunities. Patent can be licensed or sold, providing a potential revenue stream for researchers and their institutions. So as a researchers, we can also generate the revenue. Patent can be licensed or sold. We can have the exclusive right to sell our idea, and we can sell our idea for the commercialization purpose, and we can also generate the revenue. So that is also having the commercialization opportunities for the researchers. Recognition and prestige. Patents can enhance a researcher's reputation and contribute to their career advancement. Funding opportunities is also there. Securing patents can make research more attractive to investors and funding agencies. Patents can derive innovation and lead to development of new products and technology. That is the contribution to the field. Patent can drive the innovation and lead to the development of new products and technologies. So balancing patent and publications. Researchers must carefully consider the timing of patent applications and academic publications. So as a researcher, we must carefully consider the time of the patent application. What is the perfect time for patent application and academic publication? We should careful about it. And as public disclosure of an invention can affect its patentability. So we cannot disclose it publicly. Okay, we can disclose our idea whenever we can wish, but not always. We can protect it through 20 years from the date of filing. So, public disclosure of the invention can affect its patentability. Some universities have policies that require researchers to disclose inventions before publishing them. Some universities also having some policies to disclose the invention before publishing the patent. So it is crucial to understand the specific rules and regulations of the relevant patent office and researchers institution. So it is very important to understand the specific rules and regulations of the relevant patent office and the researchers institution. So balancing patent and publication is very important. Key consideration for researchers: early disclosure. So discuss potential inventions with university technology transfer offices, that is UTTO in short, University Technology Transfer Office, or patent attorneys, who are the patent person attorney, as early as possible. Freedom to operate. Assess whether existing patent might limit the ability to commercialize a new invention. We can assess the existing patent that might limit the ability to commercialize a new invention. International protection. Consider filing patents in multiple countries if commercialization is planned internationally. So, for commercialization purpose, we also can file the patent in multiple countries. Then patent claims. Work with patent attorneys to draft clear and comprehensive patent claims and that accurately protect the invention. Okay. We can also work with the patent attorney to draft clear and comprehensive patent claims that can adequately protect the invention. So what can be patented? These are the criteria: novelty, non-obviousness, utility, and examples are here. Novelty means the invention must be new and original, okay, so that it can be patented. Non-obviousness means not clear. So the invention must not be obvious or not clear to someone skilled in the particular field. Suppose I am skilled in the particular field, that is biotechnology. So my invention in biotechnology area, that may not clear to someone who is skilled in that field, biotechnology. Utility. The invention must be useful and functional. Whatever invention we are doing, our invention must be useful, having some industrial application and functional. Examples: machinery, for example 3D printers; electronics, for example smartphones; pharmaceutical, for example new drugs can be patented. Machinery, electronics, pharmaceutical, these can be patented. So these can have some novelty, newness, and new or original thing will be there. Then that should not be clear to everyone who are skilled in the particular field, and the invention must be useful and functional. Patent filing process. How to file the patent? Conduct a patent search, then prepare a patent application, then file with the patent office, examination by the patent office, then respond to office actions. Conduct a patent search. So ensure that invention is novel or new by searching existing patents and literature. Whatever the literature and existing patent is already there, you should also search that in your specific area or field. Novel, new, by searching existing patents and literature. Prepare a patent application. Draft a detailed application including claims and description. File with the patent office. Submit the application to the relevant patent office. You can file with the patent office. Examination by patent office. The patent office review the application for compliance with legal requirements. So patent office will review the application for compliance with legal requirements, respond to office actions, so address any issues or objections raised by the patent examiner. Respond to, you will wait or respond to office actions, address any issues or objections raised by the patent examiner. Conducting a patent search purpose is to ensure the invention is novel or new and avoid any infringement on the existing patents. Infringement means any चीज को उल्लंघन करना, नहीं मानना, उसको infringement बोलते हैं. Databases for patent search, USPTO, that is United States Patent and Trademark Office, WIPO, that is World Intellectual Property Organization, EPO, European Patent Office, process search for existing patents, review relevant literature and analyze findings. So these are some databases we can conduct a search of patent, USPTO, WIPO, then EPO. Okay, these are some of the databases for patent search. These are all the components of preparing a patent application: title and abstract, background and summary, detailed description, claims, drawings, if applicable, tips. So title and abstract provide a concise title and summary of the invention. So for preparing the patent application, we should provide a concise title and summary of the invention. Then we should describe the field of the invention and its purpose, that is the background and summary. We should provide a thorough explanation of the invention, that is detailed, that is claims. Then drawing, if applicable, include diagrams or illustrations to support the description. Tips: we should be clear and thorough. We should highlight the novelty, newness or utility and seek professional advice. Tips: so preparing a patent application is very, very important. We should careful of these things. Filing with the patent office, we should national patent office, for example USPTO for the United States, then international application PCT route for the international protection, forms and fees, complete the necessary forms and pay the required filing fees. That is very, very important. The examination process, initial review is there for patent. Formality check will be there to ensure all required elements are included. Substantive examination will be there, detailed review of the novelty, newness, and there should be new idea. That idea should not be clear to everybody, that is non-obviousness, and utility. There should have some usefulness, utility. That should have some industrial application or industrial applicability. Okay. Then official actions, examiner may issue office actions requesting amendment and clarification. Okay, office actions should be there. So this is for the examination process of the patent. Conclusion summary: by understanding the intricacies and difficulties of patents, researchers can effectively protect their intellectual property, contributing to the advancement of their fields and potentially translate their research into practical applications and commercial success. So it is clear to everybody? Are you getting bored? Then copyright we also know we can protect our ideas. So as a copyright holder, we will have the exclusive right of for our original work, including article, books and data sets. That may be our musical work, that may be software. Okay, so copyright grants the creator the right to control how their work is used, published and distributed. Understanding copyright is very, very important, very much crucial, vital for researchers, particularly when using materials created by others or publishing their own work. Okay, understanding copyright is very much important for researchers, particularly when we are using the materials created by others or publishing our own work. Okay, so we should protect our own idea. So key aspects of copyright in research and publication: automatic protection. Copyright protection arises automatically upon creation of work in tangible form. Copyright owners have the exclusive right to reproduce, adapt, distribute and publicly display their work. Authors' rights: authors will typically have moral rights such as right to be identified as the author and to prevent derogatory treatment of their work. Okay. Authors have the moral right. Publication agreements, while publishing in journals, authors often transfer copyright or grant license to the publication. There should have some copyright or grant license to the publishers. Okay. Then open access publishing. Open access publishing models may involve different copyright arrangements, sometimes allowing authors to retain more rights. So open access publishing model also involve different copyright arrangements. So open access publishing will be there. That is the key aspects of copyright in research and publication. Then importance for researchers, copyright protection also help researchers control the use of their work, preventing the unauthorized reproduction, plagiarism or misappropriation. So no other person can copy paste our idea. So we can protect our idea through copyright. Practical consideration for researchers using others' work. Researchers must obtain permission to use copyrighted material from other sources unless a specific exception applies. Okay. Fair use. So researcher must obtain permission to use copyrighted material from other sources unless a specific exception applies. So some practical consideration we must means, apply for as a researcher. Copyright notices, adding a copyright notice, that is capital C in the circle, comma, year, author's name to published work can help assert copyright ownership. So copyright notice also we can keep in mind. Adding a copyright notice to published work can help assert copyright ownership. Understanding agreements, researchers should carefully review publication agreements and understand the implication for their copyright. Understanding the agreements also very important for the researchers. They should carefully review the publication agreements, okay, before publishing the work. Seeking legal advice if unsure about the copyright matters, especially in complex situation. Seeking legal advice is recommended. Okay. So, journal, article, book publication, dataset publication, use of copyrighted material, plagiarism. So, researcher copy a substantial portion of another researcher's work without the permission. This is also copyright infringement. So, plagiarism we can also keep in mind. So no other researchers can copy paste our idea without our prior permission. This is also copyright infringement. Dataset publication. Researchers create a dataset and publish it. They typically retain copyright but may also license it for specific use, such as open access publication with a Creative Commons license. They should use the Creative Commons license. Okay. So use of copyrighted material. Researchers use a small quote from the copyrighted book in their research paper. If this use is considered fair dealing or fair use, it is permissible without permission. These are some example scenarios of copyright. Important consideration in copyright licensing, public agreements. Okay. Fair dealing or fair use. Protecting and commercializing research output that involves safeguarding intellectual property and turning innovative ideas or discoveries into marketable products or services. This process ensures that the benefits of research are maximized for the researcher, institution and society. So we can protect our idea and we can also commercialize our research output. Protection of research output, understanding the intellectual property, patent, copyright, trademark and design rights, trade secret. So we can protect our research output. Steps to protect research: record and document the idea of discovery, conduct prior art search to ensure the originality, engage with the institute's IP office or technology transfer office TTO, file for IP protection, example a patent application before public disclosure. We can commercialization of our research output, pathways to commercialization, licensing, startup or spin-offs, collaborative R&D with industry, consulting with and technical services. So licensing, granting rights to company to use the IP in exchange for royalties or fees. Startups creating a new company based on the research. Joint ventures to develop and market the research. That is collaborative R&D with the industry. Offering expertise and services derived from the research. You should use the consulting and technical services. We can offer expertise and services derived from the research. Key players in the commercialization, TTOs, incubators and accelerators, industry partners, legal and IP experts. So technology transfer offices bridge between academia and industry, incubators and accelerators provide support to the startups. Industry partners bringing funding, development and market access. Legal and IP experts help with contracts, licensing and IP strategy. There are some challenges and consideration. Balancing academic publication and IP protection is important. These are the challenges. Publish after filing the intellectual property. Mm. Then ensuring freedom to operate, no infringement on others' IP, understanding market needs and scalability, securing funding for product development and trials. We should keep in mind all these challenges and consideration. Then benefits of protecting commercializing research, recognition and financial returns for researchers, revenue generation for institutions. These are some benefits. Economic and social impact through innovation, job creation and industry development. Best practices, integrate IP training and awareness in research programs, develop institutional IP policies and support structures, foster or increase the culture of innovation and entrepreneurship, encourage multidisciplinary collaboration. These are all the best practices for the researchers. So recent trends in IPR for researchers, rise in university industry collaboration, increased joint patent filings, commercialization of university research via technology transfer office TTOs, AI generated invention, ongoing global debate on whether AI can be listed as an inventor. Countries like the US, UK and EU differ in stance on patent rights for AI generated outputs. So AI generated inventions are the research trends in IPR for researchers. Open access and open innovation, growth in creative common license to promote shared innovation, balancing openness with protection of valuable IP asset, patent analytics and big data in IPR, use the AI tools for patent, landscaping and prior art search, and data-driven decision making in filing and portfolio management is important. So patent analytics is the recent trend in IPR, or big data in IPR is the recent trend. Sustainable innovation and green patent, that is also important. That is the recent trend in IPR. Prioritized examination for green technologies in many countries, support for climate tech and eco-friendly inventions via patent incentives. Policy development, India's national IPR policy, that is 2016, focus on IP awareness, education, commercialization and enforcement, promotion of IP filing by academic institutions and startups, trips, flexibilities and global harmonization. So WTO's, that is World Trade Organization TRIPS agreement, encourages fair protection but allows developing nations to adapt IPR laws to public interest. For example, compulsory licensing in pharmaceutical company. That is uh, developing nation to adapt IPR laws to public interest. Ongoing discussion on IP waiver for global health emergencies like COVID-19. So there are some policy developments. BAYH Dole Act from US and similar global models encourages academic patenting by allowing researchers to retain rights over federally funded inventions. Indian draft laws inspired by this is also to boost the tech transfer. Legal considerations are there for researchers. Ownership of research IP determined by employment contracts, funding agreements, and institutional IP policies. Joint inventorship requires clear documentation. Patentability criteria will be there. What should be patented? Patent should be novel, new, non-obvious, non-obviousness. That should not clear to everybody, or everybody skilled in the particular area or field. Industrial applicability, it should have exclusions. That should be excluded from scientific theory. Uh, scientific theories are the exclusions, and mathematical methods, sometimes software algorithms are the exclusion. Then disclosure obligation, timely filing before public disclosure, conferences and publications. So timely filing before the public disclosure. Then use and non-disclosure of agreements (NDAs) when collaborating externally. So this we should keep in mind. Legal consideration should be taken care for the researchers. Ethical use of IP, avoiding plagiarism, copy paste things, copyright infringement, and patent trolling. Emphasizing benefit sharing with the indigenous communities when using traditional knowledge. IPR dispute resolution, alternative dispute resolution, that is ADR mechanism, like mediation and arbitration should be taken care. Then increasing cases of IP disputes in academia industry partnerships. So that can be, these are some IPR dispute resolution. Conclusion, for researchers, intellectual property rights are not just legal tools, but these are the strategic assets that fuel innovation, ensure credit, and foster or increase commercialization. That just not legal tools, but strategic asset for innovation, ensure credit, and foster or increase the commercialization. So we can use our IPR things to increase for the commercialization purpose. With involving with evolving global policies, AI disruptions, and legal reforms, understanding and adapting to these trends is crucial, important for maximizing research impact and societal value. So suggested keywords here are IPR, patents, research commercialization, IP policy, AI and IP, Bayh-Dole Act, and then TRIPS, university innovation, legal considerations. So conclusion and key takeaways from of IPR for researchers. So IPR play a critical role or an important role in the research ecosystem by protecting and promoting innovation, creativity, and knowledge dissemination. For researchers, understanding IPR is very important. That not only to safeguard their own work or protect their own work, but also to navigate collaborations, publications, and commercialization pathways ethically and legally. By becoming aware of various forms of IP such as patents, copyrights, trademarks, and trade secrets, researchers can also they can strategically manage their outputs to foster or increase innovation while avoiding the infringement issues. So, as a researcher, we can foster our innovation while avoiding the infringement issues. In the current knowledge-driven economy, integrating IPR awareness into research practice is very important. That is indispensable for academic, scientific, and entrepreneurial success. So IPR awareness is very important. So as a researcher, we can also aware of that intellectual property rights into the research practice. That is very that is very much indispensable for the academic, scientific, and entrepreneurial success. Integrating IPR awareness into research process also ensure that innovation is not only just created, but it also sustained and respected. Okay, so key takeaways. Okay, as a researcher, we should understand the IP types. Researchers must differentiate between patents, copyright, trademark, trade secret, and understand their relevance to various research output. Protection of research output. IPR should provide a legal framework to protect inventions, process, publications, and other creative works from unauthorized use. So no other person can use unauthorizedly, okay, without your prior permission. Okay. Then ownership and collaboration. Clearly defined IP policies are important projects, okay, to prevent disputes over ownership and usage rights. Commercialization potential. Proper IP protection can be enable researchers to license or commercialize their innovations, creating societal and economic impact. Institutional and legal support. Most universities and research institutions offer support through IP cells or technology transfer office, okay, offices. Familiarity with national and international IPR laws is very beneficial. That is vital, crucial. Okay. Then ethical and legal compliance. Awareness of IPR helps avoid plagiarism, duplication, and legal conflicts while promoting responsible research practices. So awareness of IPR will help to avoid the plagiarism issues, then duplication issues, and all the legal conflicts while promoting the responsible research practices. Then IPR and funding. Many research grants and innovation funding agencies require or support IPR filings, making it a critical component of research proposals. IPR safeguards innovation. IPR will help protect inventions, designs, and creative works, ensuring researchers receive credit and control over their contributions. So, who are the researchers who are inventing the new idea? They should receive the same credit and they should have the control over their contribution. They can protect their inventions, designs, and their creative work through the IPR. So, IPR will safeguard the innovation. Avoid infringement. Knowledge of IPR will help researchers avoid plagiarism, duplication, and legal issues, fostering or increasing ethical research practices. So, researchers to avoid plagiarism, duplication, and legal issues, and it will increase the ethical research practices that will avoid the infringement. Then, global perspective, understanding international IPR laws is very, very important for researchers working across borders or publishing globally. So, any question on? So, quote to inspire you: innovation begins with the protection. So, we must means think critically, logically. We can logically we can think. We can think new ideas, innovations. So innovation can begin with the protection. That is all about IPR. So thank you all.
Hello,
Yes, ma'am. Yes, sir. Yes. Thank you.
ma'am. I have a doubt regarding patent.
Tell me.
Ma'am, let's suppose if I am doing research on any famous personalities such as Gandhi, Nehru, or anyone, and
Yeah.
during my research writing the life sketch, I found that there is a mistake his date of birth, and with some evidence, I am able to prove that not the 2 October is the date of birth of Gandhi. Let's suppose the 3 October is the date of birth of Gandhi. So, do I am asking my question is this a matter to be patented?
Gandhi's date of birth. What you told?
हम बोल रहे हैं मैम कि मान लेते हैं कि 2 अक्टूबर गांधी का डेट ऑफ बर्थ नहीं है, 3 अक्टूबर हम किसी तरीके से अगर कोई एविडेंस से प्रूव कर पाते हैं तो क्या इस चीज को पेटेंट किया जा सकता है?
नहीं, आपको तो ठीक चीज को ही करना है ना. आप भूल चीज को कैसे प्रूव करके उसको पैटर्न बनाओगे? Your work should be original. That should have some proof. Without
Yes, ma'am.
proof, you cannot file the patent.
Yes, ma'am.
It should have some proof.
Yes, ma'am.
Otherwise, people will not believe, and that patent will be not filed.
Yes, ma'am. That is what I am
This date of
saying.
birth all will know, na. That is known to. They should have.